Okay, it's a special question I want to answer. A gentleman, he's working on a whole lot of stuff in child court custody, and he says they have some, I guess, fake do-gooders, and what he's doing is reporting a lot of misconduct in the courts, lawyers and judges. And the misconduct he's talking about is violating the rules of professional conduct and the Code of Judicial Conduct. And it's mandatory for all lawyers and judges to report any misconduct, and that's any violations in the rules of professional conduct and the Code of Judicial Conduct. And these lawyers are sitting in, listening on these complaints, and nobody's reporting. So basically, any lawyer or judge that's made aware of any misconduct, violations of the rules or the codes, they are legally obligated to report it. Okay, all attorneys have a duty to report professional misconduct of another lawyer if they know the other lawyers committed a violation that raises a substantial question about their honesty, trustworthiness, and fitness as a lawyer. Their duty is limited to specific violations such as criminal acts. They reflect adversely on the honesty, conduct involving dishonesty, fraud, or deceit. The duties do not apply to information learned through attorney-client confidentiality unless the client gives informed consent to disclose it. The key aspects of the duty to report: what must be reported. A lawyer has put another lawyer's misconduct if it violates specific rules of professional conduct, such as those involving dishonesty, deceit, misrepresentation, or criminal acts that reflect on the lawyer's fitness to participate. Knowledge requirement: the attorney must have actual knowledge of this misconduct, which can be inferred from circumstances, but is more than mere suspicion. Confidentially overrides information learned through an attorney-client relationship that is protected. So that didn't apply to him because this was like on a public forum, and laws are trying to get passed, and this is quite literally the legal system taking advantage of him, because even though they're saying they're trying to help them, they're trying to help these people figure out a way to get their kids back. Well, everything that was done to this guy was in violation of the rules and the codes. Nobody reported each other. He's bringing it up in court, and he told the judge, you have to cite the lawyers have to cite you have to cite yourself, they have to cite themselves, everybody's got to cite themselves and each other for violations of the rules and the codes. That's misconduct. Failure to report is misconduct. That's a deprivation of rights. That's a count on the judge and the attorneys. And since nobody reported each other, that equates to a conspiracy against rights under the color of law, which is violating federal law. A reporting procedure: the report should be made to the appropriate professional authorities, such as the state's disciplinary commission, unless another agency is more appropriate. Consequences for failure: failure to report mandatory misconduct can lead to professional discipline for the reporting attorney. Okay, so failure to report misconduct is misconduct. Okay, so any lawyer, any judge having knowledge of any violations of the rules or the codes is misconduct. Failure to report misconduct is misconduct, and they don't have to be a participant in the case, because seriously, what judge, what lawyer doesn't know the rules and the codes? Maybe you don't, and you should. Okay, reporting professional misconduct. Okay, that's a rule. Okay, Rule 3.8, reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises substantial questions as to that lawyer's honesty, trustworthiness, or fitness, his lawyer in other respects shall inform the appropriate professional authority. A lawyer who knows that a judge has committed a violation of applicable rules of the judicial code that raises substantial questions as to the judge's fitness for office shall inform the appropriate authority. The rule does not require disclosure of information protected by Rule 1.6 or information gained by lawyer or judge while participating in improved lawyer's assistance program. Okay, so reporting professional misconduct is mandatory. Okay, so we're going to have to go to the model rules of professional conduct, okay? Model rules of professional conduct. Okay, I don't want that. Okay, let's go to the table of contents. That's easier for me. Okay, model rules of professional conduct. This is the ABA version, which is the model rules of professional conduct, which is a standard set forth for every state, so they can add to it, but they can't take from it. Taking from of it is actually in the interest of the bar and not in the public interest, and which is strictly forbidden in the rules of professional conduct. They're allowed to enhance it, give it bite. Okay, you're gonna have to go over the preamble and the scope. We'll go over that later. Okay, but these are laws, okay, people, the terminology, so you'll learn that. Competence. A lawyer must show competence, okay. And I would say you hearing this from me and not them is a lack of Rule 1.1, okay. And you'll figure it out as we go on. There's more and more you can add. Okay, so it would be diligent if they showed their competence. It would be competent if they were diligent in communicating the legal obligations of all lawyers and judges, and that's the rules in the Code of Professional Conduct. So failure to communicate is a lack of diligence, which is the show of incompetence. Okay, so I was instructing this young man to play with words I was talking about, is that it's impossible to violate one rule when it comes to rules of professional conduct. You violate one rule, you wind up violating multiple rules. Okay, so failure to communicate is a lack of diligence and a lack of competence. They communicate that they needed to be diligent and competent in their communications with you. Clients with diminished capacities. Okay, you want to come up on that later with lawyers' responsibility to be caretakers of their assets, but they don't go by that. So you'll want to use that later. I will come upon that later, okay? Safekeeping, that's it, safekeeping property. Okay, people, you're going to want to get into that if you're in, or you know somebody that's in guardianship, probate court, okay? So it's rare that they do any of this, so you're going to want to go over safekeeping property, okay? Failure to do that, right, is incompetent. It's a lack of diligence. Did they communicate to you the requirements of wherever that was? Safekeeping property, specifically for a client with diminished capacity. Now, these are the legal obligations of all lawyers and judges. If your lawyer didn't tell you, it was the judge's duty to tell you, and the opposing party as well. They're supposed to make sure your lawyer lives up to the rules of professional conduct, abides by it, and if they don't, it's their duty to report them. Simple as that. Everybody knows this, but nobody's doing anything about it. Duties to a prospective client, well, let's just say to give you to get informed consent from you. So that would be giving you the reasonable knowledge to make an informed decision, to give that informed consent because informed consent is necessary before anything can proceed in trial. So he should tell you, or proceed to go to trial, or in the court. So he should tell you, hey, listen, you got to know all this before anybody can really bring anything in court before you. Okay, so it's it's you need that reasonable knowledge. Okay, meritorious claims and contentions. People get sued a lot for stuff that doesn't have meritorious claims and contentions, even cases brought before court. The gentleman I'm talking to about this, he's bringing this up. The lack of meritorious claims and contentions, that's a violation of the rules of professional conduct. These people are literally falsifying paperwork. He has proof to that. They're lying in court. He has proof of that. Violating the rules and the codes. Nobody. It's and he's citing them for violating Rule 3.1, meritorious claims and contentions, and their lack of expediting litigation, because this has been going on for a long time, and you could see expediting litigation is mandatory. That would be diligent. Did anybody communicate that to him? No, I was the one to communicate that to him, and this is when he got really good. He was pretty good at trying to figure out. They were holding him responsible to the same levels of that of a learned, educated professional, but yet not the learned, educated professionals themselves, which is a lack of a fair trial. That's what I was trying to explain to him. So he's not only being denied due process because of ineffective assistance of counsel. You're guaranteed effective assistance of counsel, 6th Amendment of the U.S. Constitution. No state can bypass that, because the United States Constitution is law of the land. Any law repugnant to the United States Constitution is null and void and cannot be enforced. So said Thurgood Marshall. That was decided a long time ago. Okay, so fairness to the opposing party and counsel. Hey, opposing party, you're supposed to report this guy's a lawyer for ineffective assistance of counsel. Hey, judge, if you had any honor, you would have reported this man's lawyer for ineffective assistance of counsel. See, all lawyers and judges, so just being aware of this, they don't have to be participating. Just being aware of this, being made aware of this, and failure to report this is misconduct. Failure to report misconduct is misconduct. We already went over that, okay? Partiality and decorum of the tribunal. Well, if that's saying, the judge is supposed to be, everybody in that courtroom is supposed to be impartial, but nobody's being impartial if they aren't telling you anything I'm telling you, okay? And there was an issue about this kid. He was a minor, stabbed some other kid. They were the same age, and it turns out it was from past grievances, This was an ongoing issue, so some are saying it was self-defense, others are saying otherwise. But still, he was a minor, and they put all his information out there, and, people are giving different aspects of the case. But still, I was telling the gentleman that's trial publicity. Violation of, and then once they violate this, was that competent? It's a lot of things, special responsibilities of a prosecutor. We go over that real quick. I think I went over that with you earlier. Prosecutor, in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Reasonable efforts assure that the accused has been advised of the right and to the procedure of obtaining counsel, has been given a reasonable opportunity to obtain counsel. And you go down here to the bottom, somebody was asking me about finding a lawyer to help them overturn a wrongful conviction. They have exculpatory evidence. I say, hey, when a prosecutor knows of new, credible, and material evidence creating reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, prosecutor prosecutor shall promptly disclose that evidence to appropriate court authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay. Undertake further investigations, make reasonable efforts to cause investigation to determine whether the defendant was convicted of the offense the defendant did not commit. The prosecutor knows of clear and convincing evidence to establish the defendant in the prosecutor's jurisdiction was convicted of the offense the defendant did not commit. The prosecutor shall seek to remedy that conviction. But that doesn't happen. But I'm just saying, if you got that exculpatory evidence, you're gonna need a whole bunch of people to go down there with you and try to make it as public as possible so they don't disappear you like they did or they tried with me. I'll go over that later with you. But, the pain I suffered, thought I was going to die, I wanted to die. My life flashed before my eyes, Kind of did. It was like that not stupid movie, but, you ever see that movie, It's a Wonderful Life, and the guy saw what life would be without him. Everything was cool for him, but, not those other people he was there for before he took them outside the situation. I see a lot of bad things happening to a lot of good people through deprivation of rights. You have a right to effective assistance of counsel, and effective assistance of counsel is a double-edged sword. Effective assistance of counsel is dependent on the rule of professional conduct and the Code of Judicial Conduct. That's what gives you effective assistance of counsel. So you can literally cite the opposing party, the prosecutor, and the judge for ineffective assistance of counsel for their failure to report misconduct. Reporting misconduct is mandatory in the rules of professional conduct and the Code of Judicial Conduct, and nobody abiding by the rules of professional conduct or the Code of Judicial Conduct commands that they all report each other for all such violations. Failure to do so proves a conspiracy against rights under the color of law. Truthful statements to others, like what I just said. I did not mean it. It just happened. Sometimes I just talk without thinking, and this is what I come up. Dealing with unrepresentative persons. I got arrested. The cop thought he was funny when I asked for my lawyer, and I gave him a name and number. And you want a lawyer? I got you a lawyer. And in comes the state's attorney, assistant state's attorney. And they got a little upset because I already knew that spiel. I asked them who they were, and are you a public defender? I got an attorney. Who are you? And later on, she wouldn't tell me. She just got walked out. Later on, I found out when I read the police report, it was assistant state's attorney. And they're not supposed to come and talk to you, dealing with an unrepresented person, but they'll do it anyways. Law for responsibility partners, managers, and supervisor lawyers, they're supposed to make sure everybody in their office is living up to the oath, and living up to the oath is abiding by the rules and the codes, which are the laws within a court of law for all lawyers and judges. Voluntary pro bono public service. Seriously, lawyers should be going to high schools and teaching the kids all this stuff that I talk about. That way by the time they graduate high school, they could be ready to pass the bar. Seriously, and at least they'll know what due process is. I mean, if you got to take the Constitution test, people should actually learn what due process is, and that's what I'm telling you about, the rules and the codes, the letter of the law, spirit of the law, the rule of the law. Penalties for violating those laws are harsh. So, accepting appointments, nonprofits, maintaining the integrity of the profession. And that would be abiding by the rules and the codes and reporting anybody that violates the rules and codes, because it's mandatory, and both failure to do so is misconduct. See that right there, reporting professional misconduct. Let's go there. Okay. A lawyer who knows another lawyer has committed a violation of the rules of professional conduct, it raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authorities. There's no limitations on that, okay? A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct or a substantial question as a judge's fitness for office shall inform the appropriate authorities. Okay, so reporting misconduct is mandatory. Misconduct. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowing to assist or induce another to do so, as through acts of another, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or defines a lawyer in other respects, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, engage in conduct that is prejudicial to the administration of justice, state or apply an ability to influence improperly a government agency or official, or achieve results by means of violate the rules of professional conduct, not only assist a judge or a judicial officer in the conduct that is a violation of applicable rules of judicial conduct or other law, which is the rule of professional conduct, engage in conduct that a lawyer knows, reasonably should know, is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity. See, I don't see why people are going so crazy making all these anti-LGBT, anti-gay laws. No, it says right here, engage in conduct the lawyer knows or reasonably knows is harassment or discrimination based on race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status, meaning poor folks, in conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from representation according to Rule 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules. Okay, so that's misconduct. Not doing all that other stuff. And specifically reporting misconduct. See, so any lawyer or judge that knows that any other lawyer or judge is not abiding by the rules of their codes, well, that's misconduct. Okay, that's so in, okay, preamble and scope. Judge shall uphold, promote the independence, integrity, and impartiality of judicial assurance, shall avoid impropriety and appearance of impropriety. Canon 2. Judge shall perform her duties, judicial office, impartiality, competently and diligently. A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with obligations of judicial office. For Canon 4, judge for candidate of judicial office shall not engage in political or campaign activities inconsistent with the independence of integrity, impartiality of the judiciary. Okay, where is it? Okay, let's go to Canon 1. Clients with the law. Let's see. Avoiding abuse of prestige at a judicial office. Let's see. Well, it's in the codes. I don't know what happened. The internet will tell you to report judicial misconduct. File Code of Judicial Conduct. Preamble and scope. Let me see. I like taking the shortcuts. Responding to judicial and lawyer misconduct, reporting professional. The lawyer that knows. Yes, you must report judicial misconduct. Attorney duty report attorney misconduct under the rule of professional conduct extends to judges too. Well, it doesn't say only if they're involved in the case, they just have to have knowledge, all right? Happens all the time. We'll go over the Code of Judicial Conduct, and yes, in the Code of Judicial Conduct, if they took it out, it's got to be in there somewhere. But reporting judicial misconduct and attorney misconduct is mandatory. It's mandatory, and they don't have to. They can see it on TV, and sitting back with their beer, smoking a cigarette, and next you're supposed to be jumping up, pointing that out, like that meme, the guy jumps up whistling. Yeah, so it's yes, reporting misconduct is mandatory for all lawyers and judges that have any knowledge of any lawyer or judge committing misconduct, violations of the rules and codes. anything other than that is just icing on the cake, okay? Because a lot of people tell me I got this, I got that. It says, no, first you need to know what I'm going to tell you. Right? So this is what I'm telling you. You know, this guy asked me, he got lawyers and judges listening in on him and some other people talking about deprivation of rights, you know, which is illegal. And these deprivation of rights, the deprivation of, he said this, he exposed a conspiracy against rights under law in the courts. And but nobody's doing nothing. So I'm explaining to him all the penalties for violating all these laws that he's talking about. But these people that are supposed to be helping them are supposedly lawyers and judges, or used to be judges, but lawyers now, or lawyers that are judges now. But either way, so the easiest way to get them, you know, it's the law. If he takes the rules and the codes, highlights that stuff, and tells them, hey, why ain't you doing this? It might get done faster, but then the room will vacate. I'm telling you, every time I bring up the rules and the codes to the judges and lawyers, the room vacates. You know, I've seen the courtroom vacate just at the mention of it. You know, sidebar! You know, that's like, kryptonite to Superman, you know. It's power's gone, you know, because they're acting under the color of law. You know, they're doing what they're doing, knowing it's illegal, but see, you don't know, so you think it's legal, thus the term under the color of law. You know. And them doing what they're doing, you know, that's privation of rights and working together. They conspired to deprive rights under the color of law. Okay, that's the John Q. Public. You know, asking a question. You know, you know, I mean, he asked, do these lawyers and judges, did they have to participate in the cases that these people are talking about, in order for them, it'd be mandatory for them to report misconduct. Because I'm guessing they're misleading them, saying, well, as long as they weren't involved in the case, they have no duty to report this misconduct. No, they have every duty to report this misconduct. Just having the general knowledge of any lawyer or judge violating the rules or codes is mandatory to report. Failure to report is misconduct. I'm telling you, failure to report misconduct is an epidemic. It's an epidemic in the judicial system. You know, the injustice in the justice system is because nobody's doing their job. Nobody wants to work. You know how they say that about us, you know, us laymen, you know, the backbone, the blood, the workforce of society, every society, not just, you know, the society of the United States, but in every country. You are your nation's blood. You are what gives it life, gives it breath. The heartbeat of America are the essential workers. And remember, these people, these public servants, that oath they took to the Constitution. That Constitution was written to serve and protect we the people. And if you go even back further, the Declaration of Independence, where it notes about usurpations certain inalienable rights: life, liberty, and the pursuit of happiness. And those that would usurp those rights, it is the legal duty of all the citizens to remove and replace all those that would usurp, deprive rights of anyone. And when you deprive one, you deprive all. What you take from one, you take from all. What you took from me, you took from we the people.